When should I put my home in trust? It's a question I hear a lot, especially when people learn I'm an estate planning attorney. That and when should I even get a trust? These questions basically go hand in hand and require the same answer, so let's get into it. I'm attorney Andrew Bethel, and I want to say thank you so much for watching. If you find this video helpful, please hit the like button, and if you want to see more, please subscribe and ring the bell. Of course, leave a comment below if you have any questions or have a topic you want me to cover. I try to reply to everyone, so please drop by and say hi. So when do you put your home in trust? As soon as you get it. Wait. Before you go, there are many reasons why you should put your home in trust and do so quickly. No, this isn't just me saying it because I create trust for my clients all day, but I would give the same advice even to those who don't intend to use my services. But again, as soon as you have a trust, you should put your home in trust, and if you have a home but don't have a trust, then you should get a trust and then put your home in it right away. There really is no reason to wait. The potential downsides are just too great to leave your home outside of your trust. Let's get into a couple reasons why there's no time like the present to put your home in trust. The most important reason is avoiding probate. I've talked about avoiding probate 1,000 times already, so I won't go into it all again here, but keep in mind, avoiding probate saves your heirs massively in terms of time, money, and headache. If you're a numbers person and you want to hear how much probate can cost, and spoilers, it's a lot, 5 figures minimum, then check out my video on the real cost of probate. It's old, but goes into detail on how fees are calculated. Another big reason to put your home in trust and do so quickly is because it is significantly easier to move a home to the beneficiaries of a trust than to the beneficiaries of an estate in probate court. Basically, as soon as the death certificate comes in, you're able to distribute real estate, and the only cost is a small recording fee and perhaps the fee if you have someone create the deed for you, which you should do. I would go with an attorney or a title company if you can't find one, which shouldn't be too hard. Attorneys are like mattress stores. There's more around than you'd think, and they tend to bunch up together. If we're dealing with probate, then you cannot distribute that property until you get judge approval to do so. Now, on top of the probate court problems, it has happened a few times where we record the judge's order to distribute a home in probate court, only for the county recorder's office to not understand how the ownership interests are to be reflected on title, and thus the wrong people on title for the home. Every time we've seen this happen, the county basically added more people on title to the property than there should have been, and each took months to actually fix. Then you have the fact that trusts keep matters private. Probate is court, meaning public court records open to inspection and hearings open to the public. Transfer on death deeds are also public in that your chosen beneficiary is on the face of the deed by law, which is a public record. Deeds transferring property to a trust provide the name of the trust, but not who the beneficiaries are, which is the same for most states, as it should be. Looking at you, Arizona. Really quick, let's discuss how to put your home in trust. I've gone over this in detail before, but to be brief, you transfer by deed, transferring the property from you as an individual to you as trustee of your trust. Of course, you will need to record that deed with the county recorder where the property is located, but that's a straightforward process. Just make sure you check to see what county administrative forms are required to be submitted with the deed. For example, here in California, all instruments being recorded need to include a signed preliminary change of ownership report, or else pay an extra $10 per deed. That report just tells the county what you're doing. In Nevada, for example, you need to include a declaration of value form, which has information from the deed and where you would state values for the transaction. Which, if you're transferring a property in or out of a trust, it's not a sale, so you'll be marking zeros down the line. Of course, speak to a local attorney for your specific situation. Want to know who's responsible for credit card debt after someone passes away? Watch this video here, or watch this other video.